Hello and welcome to the 2021 Lions Cup round of 16. Please ensure that you are muted unless you are submitting. Judges may keep themselves unmuted throughout the round. I will be giving you time signals, 3 minutes when you're at the 7 minute mark, 1 minute when you're at the 9 minute mark, and time at 10 minutes. Again, please note that no additional time will be granted for day 2 rounds. Please ensure your computer and phone notifications are turned silent. As a reminder to the mooters, do not inform the judges of the school you represent. Your team number and full names are sufficient. Judges are not permitted to ask or to be notified of school affiliations. Also, reminder that no feedback will be given after the rounds are over. Competitors are to return to the main room where the winner of the round will be announced. Please note that I may take photos of the round for social media purposes authorized by the 2021 Lions Cup Steering Committee. Unless there are any questions for me, whenever the judges are ready, we may begin.
Good morning, everybody. My name is Judith Schoenwald. I'm the Chief Justice for this round. And welcome, all of you. And let's get this show on the road.
Good morning, Justices. I just want to clarify if you're able to hear me and see me clearly.
Yes, I can.
Good morning, Justices. My name is Inilu Adedapo and my colleague's name is Hamza Khan, and we represent Her Majesty the Queen and Right of British Columbia, and we will be presenting submissions as the appellant today. We'll be presenting 4 submissions in total. I'll be presenting the first 2 submissions in regards to whether an Aboriginal claimant outside of Canada can rightfully claim protection under Section 35, subsection 1 of the Constitution Act of 1982, and whether the phrase Aboriginal Peoples of Canada does cover claimants outside of Canada. My partner will be presenting the second 2 submissions in regards to the Van der Peet test and whether the claimant, the respondent in this case, adequately meets all the requirements of the Van der Peet test. Before we begin, would you like a brief summary of the facts?
No, thank you.
As we begin, it is important to note that while we should be generous in our interpretation of constitutional provisions, we must also be careful that we do not interpret them too flexibly. We must be careful not to deviate from the original intent of the framers of the legislative text. Section 35 provides constitutional protection only to the rights of Aboriginal people. The main issue today is—
stop you there. Are we not talking about Section 35?
Yes, we are, Justice.
And would that not have been in 1982?
Yes.
So why are we talking about the Constitution back in 1867? Is that, I think, what you're referring to?
No, I said the Constitution Act of 1892, Justice.
Okay, of 1892?
I believe 1982, I believe.
Okay, so 1982, and let's talk about that. Let's talk about what were the framers of Section 35 intending with this provision?
That is what they were intending with the provision, specifically the phrase Aboriginal Peoples of Canada, is what we will submit that their intention was to cover originally the Aboriginal peoples then and their modern day successors who currently reside in the country of Canada today.
And what is your evidence for that?
Our evidence for that, I'll be presenting both textual analysis and philosophic analysis as well. And I will also be presenting a public policy argument as well.
Okay, so let's start to get into that. I may have some questions.
Yes, Justice. First and foremost, we must make a distinction between 2 similar but very fundamentally different questions. Whether a group is an Aboriginal people of Canada is very different from whether a group has Aboriginal rights. It is only the second question that the Van der Peet test answers, not the first question. The first question is what is called a threshold question. And what this means is
I'm not hearing anything about Section 35. So what I'm going to do is ask you a question. Let's go to Section 35.
Yes, Justice.
And in subsection 2, it actually gives us examples of who the Aboriginal peoples of Canada are, doesn't it?
Yes, it does, Justice.
Okay, but the way that it does that is it says includes the Indian, Inuit, and Métis people of Canada. That's not an exhaustive definition, is it, when it says includes?
No, it's not, Justice.
So then would the intention of the people who drafted this then also indicate here from the fact that it is an expansive definition that they did not want it to be restricted, that they did anticipate that this may be interpreted more broadly after 1982.
Yes, Justice. We are not arguing that the text is supposed to. We understand that the constitutional text is a living, breathing document. As such, we are not arguing necessarily that it has to be interpreted rigidly. As I stated, that yes, we must be flexible in our interpretation. However, we must still have certain limits to how we interpret the legislative text. For example, in Manitoba Métis against Attorney General, they stated that Section 35, subsection 1 must be interpreted in a generous manner, yet one that is consistent with its intended purpose. As such, that's what we're submitting today. You made the right assertion. Sorry, Justice, did you want to say something?
No, I'm just trying to see then, where is your argument? How is it inconsistent? How is the decision by the majority of the Supreme Court of Canada inconsistent with Section 35?
Well, the ambiguity or the main issue, as I've stated, comes with the phrase "of Canada." What we are arguing is that every other time where the Constitution Act uses the phrase "of Canada," what it is saying, what is being clearly implied there, is that it is making a geographic qualifier. That is what we are stating. As such, we are not to interpret subsection 1 by itself. It's not an isolated text. Rather, when we interpret it within the broader context of the Constitution Act or within Section 35, we see that "of Canada" in subsection 1 is supposed to act as a geographic qualifier.
Okay. So then, Counsel, you mentioned a case called Vanderpeet, right? You mentioned that?
The Vanderpeet test, yes.
Yes. So can I take you to Vanderpeet then, paragraph 25?
I can pull that up, Justice. Yes, Justice.
And the very first sentence there says, if there is any doubt or ambiguity as to what falls within the scope and definition of Section 35, that it must be resolved in favor of Aboriginal peoples. Isn't that what Vanderpeet says at paragraph 25?
Paragraph 25, my apologies, I was at 35. Yes, it is. Yes, that's what it says, Justice.
So doesn't that stand directly contradictory to what your submissions were just there?
Not necessarily, Justice. I am not arguing the Vanderpeet test yet. That will be submissions that my co-counsel will make. What I'm arguing is Section 35, subsection 1, the ambiguity of the phrase Aboriginal peoples of Canada. I am not necessarily touching Vanderpeet test. My submission is in regards to the fact that we must first pass the threshold question before we even proceed to the Vanderpeet test. We must first clarify that the respondent actually is an Aboriginal peoples of Canada as intended by the framers of Section 35 before we ask if the respondent actually passes the prongs of the Vanderpeet test.
Okay, I'm willing to hear those submissions, Counsel, but I do think that first sentence in section paragraph 25 of the Vanderpeet case actually does address that specific issue. So feel free to make submissions on that point.
As we continue from that, there are certain presumptions that are made in interpreting constitutional text. One of those is the presumption of consistent expression, which states that it is presumed that legislative texts are drafted carefully, so that each and every word has a specific meaning and words not used for simply aesthetic or rhetorical effect. As such, in trying to interpret the ambiguous phrase Aboriginal peoples of Canada, it is important that we look at the larger context of Section 35 and see how else similar phrasing is used. For example, we know in subsection 3, 6, and 23, the phrase citizen of Canada is used. In section 16, the phrase official languages of Canada is used, and there are many more examples such as this. The argument is that it is unlikely that, for example, that we can interpret the citizen of Canada to apply to anyone outside of Canada, the phrase official languages of Canada to apply to any individuals outside of Canada. The question then is, why should we why should we believe that the original framers intended the phrase Aboriginal peoples of Canada to be able to apply to people outside of Canada? Furthermore, the question can be asked that if they did not intend the phrase of Canada to apply as a geographic qualifier, it could simply be left as Aboriginal peoples. For any reasonable person reading a legislative text that applies to Canada knows that this text will not apply to any other sovereign state. As such, if this phrase of Canada
Counsel, sorry to interrupt you. You said that, anyone reading the legislation would just know, but I don't think they would just know, right? I think the framers weren't clear. I think that's why we're here, partly why we're here today. And so when you're talking about the threshold question, the trial judge did find, in fact, that the Sinai occupied territory, which is now British Columbia, at the time of European contact, and the Lakes Tribe people are now the modern successor. So does that not then justify calling them Aboriginal peoples of Canada because they are successors? We all identify, all of our identities, come down from our descendants, and we are folks of a certain land for that reason. So why not have the same logic apply to, folks of the Lakes Tribe people?
In response to that, Justice, I said any reasonable person, and what you have said is very important. I would like to point us to Lamer CJ, which held in Vanderbilt test, paragraph 21. The purpose of the Vanderbilt test should be understood in relation to the interest it was meant to protect. And the interest it was meant to protect was to further reconciliation between non-Aboriginal Canadians and Aboriginal peoples. As such, it would be very difficult for us to try and—
Counsel, does it say Aboriginal Canadians or Aboriginal peoples?
I believe it says fully Aboriginal peoples of Canada, I believe. My apologies. Full participant with non-Aboriginal peoples and a shared Canadian sovereignty with Aboriginal peoples.
Aboriginal peoples, but not Aboriginal peoples of Canada, right?
No.
Okay.
As such, if I can continue responding to the former justice's question, it's why does it not relate to groups outside of Canada? We believe that it cannot relate because it would create certain public policy issues. For example, for them to be able to claim rights under Section 35, that could also set a precedent for them to be able to claim land title rights, which would certainly be absurd because that would give them the right to have a say in what the land can be used for, despite them not geographically living in Canada.
But Counsel, you mentioned that one of the most important parts is reconciliation. So then aren't land rights part of that reconciliation process?
Yes, they are part of the reconciliation process. However, we still have to be careful as this is a test case. See, I would just quickly end, my apologies. We still have to be careful as this is a test case to make sure that we address any possible public policy issues that our judgment in this case might give rise to. And I would just quickly pass it over to my co-counsel who will be speaking in regards, my apologies, who will be speaking in regards to the Vanderbilt test and the argument of continuity, whether the respondent fulfills all the prongs of Vanderbilt test. Thank you, Justice.
Thank you, Counsel.
Good afternoon, Justices. My name is Hamza Khan, and as my co-counsel Nyolua Adedpo told you, we are counsel for the appellant. I have two main submissions today, one regarding the continuity part of the Vanderbilt test, and another regarding the public policy implications of overturning this lower court case. I'd like to launch first into public policies. I believe it was an issue brought up with some of the questions to my co-counsel. One issue brought up was that one of the more important points regarding this case is that of reconciliation. And we as counsel for the appellant entirely agreed that this case must be decided in line with reconciliation with the Aboriginal peoples of Canada as what would be in the best interest for them. And so we submit that to allow this lower court decision to stand may have deleterious effects, not only on the Crown, but also on those Indigenous peoples who reside within Canada. This is not merely a case of the Crown dragging its feet to not want to consult, but rather that to allow the lower court decision to stand may have some negative impact on those who we are trying to protect and reconcile within the legal system. My argument for that, Justice, is that to grant a group which currently resides outside of Canada right to hunt within a traditionally Aboriginal part of the country, within British Columbia, where we had multiple tribes we know have been living there, and where may create conflict with those Indigenous groups already in Canada who may also have similar rights to that same land. And when we have a conflict between those who have land within Washington state, who have their own modern day area within Washington state, and those within Canada.
Do you have any specific examples of, let's say, Aboriginal peoples in Canada who would have conflicting claims?
So the one example, Justice, would be, and it's not a modern day issue, but the one issue would be those individuals who had resided within Canada after the majority of the Sinixt had left to America. Had those individuals maintained a presence within Canada, that would have brought up a potential issue with now the individuals claiming. That's not an issue here because those individuals eventually that tribe no longer exists. However, as a test case, we could have scenarios such as that in the future where we have a tribe splitting, some individuals moving to America and some within Canada, and to allow this lower court decision to stand could have impacts in cases like this. We can imagine that had the Sinaiks within Canada continued to live and hunt within the area, that to grant away some of their rights to a group that had moved into America would cause a conflict and deleterious effects for that group that had remained within Canada. So it's not specific to this case, but there are possibilities and hypothetical scenarios that we have to consider when we're looking at the downstream effects of this case. And so
Counsel, let me make sure I understand this. Are you saying
Yes,
that they don't exist anymore in Canada? The descendants of the original people who inhabited this area?
what I'm saying is that there was a declaration of extinguishment, not that they don't exist within Canada, but that there isn't a formalized group that can apply for Aboriginal rights and have not exerted hunting rights within British Columbia up until this point. Not that they don't exist, but they haven't applied for the Aboriginal right to hunt within Canada. Had they done that and had they had a more pronounced presence in Canada, that could have led to one of the greater conflicts that I'm alluding to with the instances of letting this lower court decision stand.
But the people themselves still existed, right?
Yes, the people themselves still exist within Canada. I'm not denying that the people of the Snakes tribe still exist within Canada, and that itself may cause a problem when we have groups from America trying to claim that land. And so we can see that there might still even be a conflict in this case. If the individuals who still exist from the Sinaiks tribe decide in some future time to also apply for Aboriginal right, as would that be their right because they are the individuals who remained in Canada, the fact that we are granting Aboriginal right to another group may cause conflict there, may prevent those individuals residing within Canada. The Sinaiks tribe that's remained within Canada may result in them not being able to achieve those rights because they don't have exclusive occupation or exclusive rights within the British Columbia territory that they're now trying to
Counsel,
claim.
are you saying that there might be issue in the future between the Sinai and the Lakes tribe people?
What I'm suggesting is that's a possibility. As we said, the Snakes still exist within British Columbia. It's not that the group does not exist.
But aren't the Lakes tribe people the modern successors of the Sinai? So here we are. So aren't we sort of? You're providing us with a hypothetical situation where the modern successors of their original ancestral descendants are going to have a potential argument or disagreement or issue between themselves for Aboriginal rights. Is that correct?
So if I can explain a bit on the issue, when the Sinaiks, when a large group of the Sinaiks had left into Washington state, there was a group that remained within Canada. Now the group that moved to Washington state has now been called the Lakes tribe, but there was still a group of the Sinaiks people living within British Columbia. And so I'm not saying that it's a probabilistic problem that might arise or even a likely problem. I'm simply pointing to the kinds of problems which may arise in other situations. Certainly the Sinaiks are not the only cross-border tribe that exists. And so I'm not pointing that as a likely scenario, but we do have two distinct, to an extent, groups of people here, the Sinaiks that remained in Canada and the Sinaiks that left to Washington and are now called the Lakes tribe.
So even if we accept this as, a probabilistic sort of potential issue, how does this relate then to what we're talking about right now? How does this allow us to determine whether we should provide Mr. Desautel with his rights or not?
So and if I can explain that, what I'm getting to is the public policy implications. What I'm trying to get at here is that to allow the lower court decision to stand would exacerbate those conflicts in the future. To say that the group that moved into America now has claim or rights within the territory that currently and in the past was occupied by the Sinaiks that stayed may exacerbate those conflicts. And so it's not simply deleterious effects on the Crown or Canadian government, but rather deleterious effects even on those Indigenous individuals that reside within Canada and have always resided within Canada, not just other Aboriginal groups. And so that is the real public policy issues that we have to consider. Justice Cote in his dissent provided some reasons regarding the Crown. However, we submit that the strongest public policy considerations here is in fact reconciliation, that to protect the Aboriginal rights and the Aboriginal land of those who currently reside in Canada, don't have another country to go to, such as the Lakes Tribe, which already reside within Washington State and have a designated area in that area. To launch into my second submission, and I'll try to keep this brief because I recognize I don't have much time, but in terms of the continuity issue at hand here, the lower court said that there's a period of dormancy in hunting between the years of 1930 and 1976. However, we submit that the actual period of dormancy was from 1930 onwards until Mr. Desautel shot the deer within British Columbia. This is for the reason the continuity of the practice has to be a legitimate resumption of the practice, or some at least attempt to hunt within British Columbia. But in the year of 1976, this was not anything that broke this dormancy, as it was simply one individual inquiring about the lands within Canada. And so this couldn't break the chain of dormancy when we're looking at actual hunting in British Columbia. Had there been an attempt to resume hunting, had there been a legitimate enterprise or a request to allow hunting in British Columbia, this could have a much stronger argument for continuity. However, the 1976 state.
The Vanderpeet test says very clearly, I think, that a lapse of time is allowed, that you don't need a continuous chain to occur. So why can't we accept Mr. Desautel's hunting of the cow elk as the first time that the chain was attempted to give a rebuild to?
Yeah, so we acknowledge the fact that there doesn't need to be an unbroken chain. However, there is some limit as to what not being an unbroken chain can constitute. Here we have a gap of 80 years between 1930 and 2010. And we would submit that this 80-year gap without any attempt to resume hunting, without any request to resume hunting, would constitute a break in the chain of continuity. And so just to resolve some of the submissions that me and my co-counsel provided, my co-counsel has provided you with submissions and evidence that Section 35 is specific to those individuals residing within Canada currently. The Aboriginal peoples of Canada would refer to those residing within Canada at the current time, and so cannot apply to the claim of Mr. Desautel, who is not residing within Canada, does not belong to a group that is currently residing within Canada. And I have given you reason that the public policy implications of letting the lower court decision stand would have deleterious effects on those exact same Aboriginal peoples of Canada that reside here. And finally, we have provided submissions and evidence that the continuity test of the Vanderpeet case has been broken because of the 80-year gap without any attempt to resume hunting within British Columbia. For those reasons, Justices, we ask that you overturn the lower court's decision and reinstate charges against Mr. Desautel. Thank you.
Thank you. I believe that concludes Team 17. So Team 25.
That would be me. Am I allowed to time on the side myself just to keep an eye on everything? Thank you very much. I'm assuming that means everyone can hear me here as well. Perfect. Great. Good day, Justices. My name is Madison Fanugapal, and I'm here alongside my co-counsel, Melanie Davidson, on behalf of the respondent, Mr. Richard Lee Desautel. The issue on appeal is whether an Aboriginal people located outside of Canada can assert rights protected under Section 35, subsection 1 of the Constitution Act of 1982, hereby referred to as the Act. In this case, the respondent, Mr. Desautel, claims an existing Aboriginal right in Canada as a member of the Lakes Tribe of the Confederated Tribes of the Colville Reservation, hereby referred to as the Lakes Tribe, situated in Washington State, USA. The respondent's submissions will be fourfold, and I will take these first two. First, a purposive interpretation of Section 35, subsection 1 establishes that Aboriginal groups located outside of Canada are entitled to constitutionally protected rights if they are able to demonstrate prior occupation of Canadian territory. Second, the Vanderpeet analysis confirms that the pre-contact practice of ceremonial hunting is an integral feature of the modern Lakes Tribe, and on the basis of continuity, should entitle Mr. Desautel to rights under Section 35. My co-counsel will carry the latter half of the respondent's submissions with reasons why the alternative wordings of section 35 subsection 1 must be taken in the context of the Vanderpeet analysis, and that granting section 35 subsection 1 rights to Aboriginal peoples not located in Canada does not raise any constitutional concerns. Should your honors find the respondent's submissions to be true, we ask that you dismiss the appeal and answer the constitutional question in the affirmative. I will now discuss why a purposive interpretation of section 35 subsection 1 establishes that Aboriginal groups that are located outside of Canada are indeed entitled to constitutionally protected rights if they are able to demonstrate a prior occupation of Canadian territory.
Counsel, I'm going to help you out here in terms of the interest of the bench, at least from this perspective. I don't think it's controversial, at least based on the majority decision of the Supreme Court of Canada, that a purposive interpretation could give rise to these rights. I guess for me, the bigger question is whether or not it should in this particular case. Okay, I assume that you're relying on Vanderpeet for the purpose of
that will be my second submission. Yes, I will rely on Vanderpeet analysis.
Let's do that now, and I'm going to take you to paragraph 28 of Vanderpeet.
28, if I may have if the appellant may have a moment here.
The second sentence there says that at common law, Aboriginal rights did not have constitutional status, and Parliament could extinguish those rights. You see that sentence there? And so my problem here, and maybe you can help assist me in terms of how I reconcile this, is that it's only in 1982 that these rights became constitutional. Prior to that, Parliament did, in fact, extinguish the hunting rights of the Sinixt people in the 50s, well before 1982. And so if we look at section 35, it says the existing Aboriginal and treaty rights of Aboriginal people are hereby recognized and affirmed. But in this case, those rights didn't exist, not in 1982. And so how do we reconcile that?
Sorry, may I just ask you to rephrase your question just right at the end there?
Section 35 sub 1 says that the existing Aboriginal and treaty rights of Aboriginal peoples are hereby recognized and affirmed. In my reading here, it looks like there were no hunting rights for the Sinixt people, at least the ones who live in Washington, in 1982. In other words, those were not existing rights. So how do we reconcile that?
If I may have just a moment to conclude my thoughts here. What we want to ensure is that we're not ignoring this special history that the Aboriginal group in question has with the Crown. And we understand that the rights at play do have a very intriguing history and that certain rights were established in later years. However, as I've mentioned, the Aboriginal peoples in question did have a very special relationship with the Crown in terms of the honor of the Crown. And it was observed by Justice Lamer in the Vanderpeet that he said, and I quote, "The constitutional framework through which the fact that Aboriginals lived on the land in distinctive societies with their own practices, traditions, and cultures is acknowledged and reconciled with the sovereignty of the Crown. And it's imperative that we consider this history when we are discussing these rights." Of course, this is very case specific, but it is very important given this particular group's history with hunting on Canadian territory to consider. I will jump right into the Vanderpeet analysis as I realize that the concept of continuity is integral to considering whether or not we should grant Mr. Desautel his Section 35 rights. According to the Vanderpeet analysis, if an Aboriginal group outside of Canada can demonstrate that the pre-contact practice is integral to its distinctive pre-contact Aboriginal society, and that has a reasonable degree of continuity with the pre-contact practice, then the Aboriginal group in question will receive full recognition of their Section 35 subsection 1 rights.
Sorry, Counsel, I'm suggesting that Vanderpeet actually makes an analysis of Aboriginal rights for people outside of Canada. Is that what you're suggesting?
We're saying that the respondent submits that with the additional history of the Sinixt group and the modern successor group, the Lakes tribe, that the Vanderpeet analysis is a correct test to understand these rights, and that and that on the basis of continuity, we can still establish that there is an affiliation with this traditional territory.
Okay, but Vanderpeet never addressed the particular and specific issue that's before the court here today, right?
Although it didn't, we're still applying the basis of the Vanderpeet test to this specific case.
Counsel, I have a question for you. Paragraph 108 in the Supreme Court Canada decision, it says, the presumption of consistent expression also sheds light on how the phrase of Canada in Section 35 ought to be interpreted. As Sullivan notes, it is presumed that the legislature uses language carefully and consistently so that within a statute or other legislative instrument, the same words have the same meaning and different words have different meanings. My question is, it is clear to me, at least, that Section 35 clearly clarifies who the Aboriginal people of Canada is, what constitutes a Canadian, giving them protection. How would you reconcile the fact that your client is an American citizen, and in our interpretation of Section 35, these protections may not be extended to him?
So the respondent would submit that a consistent development of Section 35 jurisprudence would require that groups who are located outside of Canada can actually be considered Aboriginal peoples of Canada, because the purpose of Section 35 is important, and that's twofold. First, it's to recognize prior occupation of Canada by organized autonomous societies, which we see was the previous group, the Sinix tribe. And second, to reconcile their modern day existence with the Crown's assertion of sovereignty over them. So on this interpretation, the scope of Aboriginal peoples of Canada becomes clear. We see that modern day successors of Aboriginal societies that occupied Canadian territory at the time of European contact, even if they are currently wholly located outside of Canada, can and should be considered Aboriginal peoples of Canada. I actually have
how do we then, the submissions that were made by your friends, raise the very intriguing issue about conflicting rights then between an Indigenous group that is now in the US, that has been in the US since before there was a Canada, and Indigenous groups that are in Canada that have conflicting claims there. And this isn't just theoretical. We actually know that many of the Sinix people joined what is now the Courtroom Nation in BC. They intermarried and they became part of that, and there's a greater continuity there. So how do we have to balance, one claim of continuity against another?
Of course, it's all very fact specific, and I see that my time is about to elapse. May I ask that you rephrase that question just a small bit there, and then I will conclude.
Should we be balancing competing claims of continuity?
Of course, it's very, as I mentioned, it is very fact specific, and in this particular case, the continuity here is not broken as the appellant may have you believe. We submit that it's not necessary to prove a connection between the pre-contact practice and modern practices of ceremonial hunting by the Lakes Tribe territory, or the Lakes Tribe in British Columbia territory. And given that there is this continuity, given that there is this continuity, we believe that this satisfies the Vanderpeet test. So barring any further questions, my co-counsel will carry the balance of the respondent submissions.
Thank you.
May I also time myself?
Yes, you can.
Good morning, Justices. My name is Melanie Davidson, and I will be concluding the submissions begun by my co-counsel, Madison Venugopal, on behalf of the respondent. I have two submissions before the court today. First, that the wording of Section 35 must be interpreted in light of the Vanderpeet case. And second, that granting Section 35 rights to Aboriginal peoples that are not located in Canada would not cause constitutional issues as submitted by the appellant. First, on the issue of the wording of Section 35, admittedly, the wording is vague, such that it can be molded to mean whatever the reader wishes it to mean should they read Section 35 in isolation. However, it is very important to not fall into that trap and to not read Section 35 in isolation. Section 35 was actually interpreted by the court in Vanderpeet, and regardless if that interpretation was specific to Aboriginal peoples in Canada, the underlying principles actually do help this court in this case. When determining the scope of the phrase Aboriginal people of Canada, the court must consider historic practices pre-contact and then recognize those practices as rights held by modern day successors of Aboriginal peoples who lived in Canada pre-contact, should those rights claim meet the Vanderpeet test. The phrase Aboriginal peoples of Canada cannot be taken out of context, such that geographic location trumps the historical link between modern day Aboriginal peoples and their ancestors, thereby excluding those peoples from Section 35. Moving on to the constitutional issues. One of the big constitutional issues in this case that was submitted by the appellant pertained to focusing on granting rights to Aboriginal peoples who are currently in Canada, with a submission stating that to grant rights to Aboriginal peoples outside of Canada may detract from reconciliation with Aboriginal peoples in Canada. With all due respect, this is a line of reasoning that would lead this court into error. We cannot prioritize one group over another when both groups have valid claims to Aboriginal title in parts of Canada.
Counsel, isn't that what the government of Canada is doing right now? They're in treaty negotiations with the Courtroom Nation, part of whom, at least in their eastern part, as I understand it, include the descendants of the Senex people. So like the government is doing exactly that right now as we speak. So why can't we do that? I think that's what I'm puzzled about.
The entire issue with prioritization actually comes down more to the duty to consult and how that would manifest with Indigenous groups and Aboriginal groups who are located outside of Canada. As we know, the duty to consult arises from the principle of Crown sovereignty. When Aboriginal groups are located outside of Canada, the notion of Crown sovereignty changes a little bit because those groups are no longer subject to Crown sovereignty. So generally speaking, when an Aboriginal group seeks to make a claim to the land, they have to notify the Crown of that claim. Otherwise, there is a presumption in Canada that when an Aboriginal group is located in Canada, the Crown may have pre-existing knowledge that an Aboriginal group may have claim to land or right or title because they are located in Canada.
I was going to ask you, there is a difference here though, right? Between a hunting right and a claim to title, or right, or claim to a different type of practice. These are different types of claims, right?
Absolutely, yes.
And
yes.
So then potentially we may have land title claims by non-Canadians. That's really what your suggestion is here.
That is a possibility. That is not the suggestion. Just in the discussion of duty to consult, it is important to mention land title claims because that is one of the claims that can be brought to the Crown, but it is not the only claim. There are claims, rights claims, which would fall into the hunting rights, which we are looking at in this particular case. So in that case, the main issue that would arise with Aboriginal groups who are located outside of Canada is that the expectation that the Crown will have knowledge of their rights claim or their title claim is not the same as the Crown's expectation of having knowledge for groups who are in Canada, because there is a different relationship, because those Aboriginal groups are not under the Crown's sovereignty. So at this point, that is when we get into a case-by-case factual analysis.
So the problem that I'm having here, Counsel, is that if the courts are going to be playing this role where we're getting into a case-by-case factual analysis, it could be directly interfering with reconciliation efforts that are actively underway right now. Like I said, this piece of land is exactly right now being discussed by the federal government with different Indigenous people who are Canadians. And that seems to be a very particular challenge where you're asking the court then on a case-by-case basis, to interfere with the legislature's negotiations that are on an ongoing basis?
In this situation, of course, Aboriginal rights are very complex. They intersect, especially when we are looking back at rights that descend from a group's ancestry dating to pre-colonial times. There are going to be groups with intersecting interests. However, when that group makes a specific rights claim, if the Crown is in negotiations with another group, that is when they will have to determine what their duty is. They will have to determine how they will address that intersectionality, and they will have to determine how they can try to accommodate both parties' rights and both parties' interests.
Counsel, may I direct your attention to paragraph 114, the case at bar, not the one repeat, but the case what we are arguing about right now. And it says that it refers to one repeated paragraph 21, that section 35(1)'s purpose should be understood in relation to the interests it was meant to protect.
Mhm.
The interest, and it was raised by the appellant. Those interests, we are talking about the interest within the sovereign territory of Canada,
Mhm.
as opposed to another country. And also paragraph 114 goes on to interpret that these constitutional protections are strictly for Aboriginal people who are residing within Canada. How do you, again, we are coming back to the same question, how do you reconcile the competing interests between Aboriginal people who live in Canada as of outside, especially when we are talking about sharing resources and sharing scarce resources?
And I'm going to add to that because I think it's the same question. That same paragraph refers to Mitchell at paragraph 135.
Yes.
And so if you look at Mitchell, it refers to, again, the purposes of section 35, that Aboriginal peoples do not stand in opposition, nor are they subjugated by Canadian sovereignty. They are part of it. What I think, the interpretation that you're providing here would suggest that Aboriginal people who are not in Canada and are, in a different sovereignty, the United States, are also in some way part of the sovereignty in Canada as well. That seems to be a little bit confusing for me, especially if we're trying to look at a purpose of section 35.
Absolutely.
And actually, sorry, before you continue, the paragraph right after clearly states that there's no historical record showing this expansion of protection under section 35(1). In fact, the limited that exists in terms of, evidence or historical sources simply points to what your friend said about Aboriginal peoples of Canada and supports the fact that, they want to limit this constitutional protection. So how then do we reconcile all of this?
With all due respect, the respondent would point the courts to look at Vanderpeet. Vanderpeet does provide an interpretation of section 35, and Vanderpeet does actually explicitly direct the courts to look at pre-contact Aboriginal societies and those treaty rights.
Where would you like for us to look at in Vanderpeet, where it actually resolves this issue?
That would be, if I may have a moment to consult my notes, please. That would be in paragraph 43 of Vanderpeet. In paragraph 43 of Vanderpeet, the court does actually explicitly direct to section 35 rights that are prior to the arrival of Europeans, and also to looking at the Crown sovereignty as related to that, and also Aboriginal rights as related to those Aboriginal peoples who were here prior to the colonial interference of Canada. My apologies for my lack of better words. I see that my time is elapsing. May I have a moment to conclude?
Counsel, you can only have up to 15 seconds.
In light of this, we ask that you dismiss the appeal and answer the constitutional question in the affirmative. Barring any further questions, the respondent rests.
Thank you,
Thank
Counsel.
you.
Thank you all for your submissions. The judges will now deliberate. If everyone besides the honorable justices could kindly clear the room using the leave breakout room button at the bottom of your screen, you will not be permitted to re-enter as there is no judge feedback. Please stay in the courthouse lobby for advancement announcements. Thank you.
Thanks, everyone. Nice round.
Thanks, everyone.
Thank you very much.